Ladies and gentlemen, welcome back to the IndieZone here on YouTube. My name is Kathy. Just a short while ago, today, December 31st, 2024, the clerk of court released the very explosive, in my personal opinion, that I give pursuant to the First Amendment to the United States Constitution, December 27th, motion to compel, ICR, 16B7 material and for sanctions. If you've been following this channel, you know that we have been closely monitoring the docket over the past several days to see when this document was released. You can go to the Idaho Cases of Judicial Interest link that I have provided to the description to this podcast episode and look at this entire document for yourself. I would like to read a bit of it to you. I say it's explosive because here the defense who filed this motion to compel and for sanctions states that the state of Idaho has disclosed 25 expert witnesses. Well, only 5 of them disclosed expert reports, and this is what Judge Stephen Hippler told the defense and the state, that both the curriculum vitae for any expert witnesses and expert reports were to be disclosed by the state on December 18th, 2024. Page 1 says that Mr. Kohberger, by and through his attorneys, are coming forward. They're asking for an order to compel. What is a motion? A motion is an application for a court order to compel, to require the other side to do something here to comply with a prior court order, and also for sanctions is what's being asked here. The defense is alleging that the bulk of the state's expert disclosures, and this is for trial, ladies and gentlemen, fail to include opinions and reports. This is exactly what we thought the defense might be filing when we first noted this filing on the docket last week. It's the opinions and reports that have not been produced, at least according to the defense. Goes on and says these are inadequate disclosures that greatly prejudice Mr. Kohberger, who was obligated to submit defense guilt phase expert disclosures by January 23rd, 2025, again returning to the Judge Hippler October 9th, 2025 order. This is exactly what it states. The defense guilt phase expert disclosures to the state must occur on or before January 23rd, 2025. Mr. Kohberger is alleging because the state failed to produce their disclosures for guilt phase that they are now prejudiced. The sanctions considered must be the exclusion of the experts. So he wants all of the experts who have not complied to be excluded from testifying at trial, or at a bare minimum, an order compelling proper disclosures and an extension of Mr. Kohberger's January 23rd, 2025 deadline. There's a footnote here. Mr. Kohberger does not include here a motion to strike the death penalty for failure to properly disclose experts. Without proper disclosure, that motion is forthcoming. So now they're going to seek a motion to strike the DP for failure to comply with these expert disclosures. That's what this is forthcoming means. Not filed yet, but it's coming. Mr. Kohberger, as grounds for these sanctions, defense claims, is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront. That is why the state goes first. They have the burden of proof. So they're supposed to disclose their experts per Judge Hippler's order to include what the opinions, what Mr. Kohberger can expect that these experts will testify to at trial. Now, in the next section, you will see there are over 68 terabytes of discovery produced in a method that the defense has repeatedly referenced in pleadings and at various motion hearings as extremely disorganized. There have been 20 specific requests for discovery, 6 motions to compel filed by the defense. Well, after this was filed, there was a 21st supplemental discovery request that was filed. The court entered a redacted order governing further criminal proceedings and notice of trial setting. That is the blueprint, ladies and gentlemen, that I have constantly referred to. And I do ask that if you have an interest in this case, if you're doing research on it, to please pull down that document and really print it and have it close to you, because it is the blueprint for everything that's supposed to be happening. Key events through the trial of this case, which will occur in the summer of 2025. So the defense is now referring to the October 9th, 2024 order and has notified the parties that strict compliance with the court's order is expected. Judge Hippler has basically told both parties you will comply with these directives contained in this October 9th order. I call it the pretrial and trial order. Now, on December 18th, the state disclosed 25 experts. Of those, only 5 include actual expert reports. Notably, not a single DNA expert opinion or report was produced. Instead, the state's disclosures refer to Bates numbered pages and say, and then they go ahead and they quote what those statements are. At least 3 digital forensic experts are disclosed with lists of 67 electronic devices or third-party databases examined. Not a single report of what these 3 experts will opine. Opine means what is their opinion going to be if, number 1, Judge Hippler accepts those experts and they are permitted to testify at trial before the jury as the trier of fact. Remember, Judge Hippler is the gatekeeper to avoid any junk science from coming in, and he must make that determination as to whether any of the defense or state expert witnesses will testify. These expert reports are what should have the information that these experts will opine, will give at trial, and the defense is saying that they have basically blown off Judge Hippler's order. You will read the rest of the argument why Mr. Kohberger feels that sanctions should be imposed here and why he feels he is being prejudiced. He cites 2 rules of court and legal authority, pages 3 and 4, and interestingly, all 3 defense counsel have signed this motion. This is very unusual. Usually it'll be Ann Taylor, Jay Logston, or Alyssa Massoff. All 3 have signed this and stated here, concluding Mr. Kohberger must be able to confront the evidence against him. And to do that, it must be disclosed in accordance with Idaho Rule 16 and this court's order. That's the order of October 9th, 2024. The expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures by January 23rd, 2025, signed by all 3 defense witnesses. If you have any comments, any feedback, any questions, please leave them here. They're all appreciated. Next, we will wait to see what the state says in response. Until then, this is Kathy. Thank you as always for joining us here today.